Hi, welcome to BL Business Branding. I'm your host, Nick Martinez, here with my coworker, Isabel Wadsworth. Today we're going to be talking about parody versus trademark and trying to figure out where's the line.
Yes.
So the case at issue here has been going on for over 10 years now, where they say that imitation is the most sincere form of flattery, but
Right.
here we have Jack Daniels disagreeing.
Yes. So this is a really fun case that we're going to be talking about today, and a really good illustration of how trademark law can really be found in the most everyday of places. So for those of you who have pets and you see your pet playing with their favorite dog toy at home, we hope that you remember this conversation. It really is a true illustration of how trademark law can touch, like I said, every aspect of our lives. It's really interesting. So here's the backstory of this case. VIP Products, the company at issue in this case, made a dog toy that arguably mimicked the Jack Daniels whiskey bottle, and it was called Bad Spaniels. Instead of Jack Spaniels, Bad Spaniels. We can all sit here and laugh about it, but like you mentioned, Jack Daniels didn't find it funny. So visually, it was a spot-on parody in terms of the products. Same shape, same font, except with that, dog humor timed in there. And so, yeah, Jack Daniels did not think this was super funny. And so they decided to sue VIP Products, and they sued for trademark infringement, arguing that consumers of VIP Products' Bad Spaniels bottle, as you can see on the screen there, might think that the brand Jack Daniels endorsed the toy. So it's a really interesting case, and again, you would look at this dog toy, maybe you have something similar in your home and not think it would bring about this huge trademark dispute, which is what makes it so fascinating.
Well, I think something that's really interesting with all of these cans up there is it kind of goes to the strength of the underlying product,
Right.
where this Corona Mexican beer and this Lick Croy, neither of those are direct comparisons to the instant brand that pops into your head as soon as you saw that bottle. You see this, and right away you're probably thinking Red Bull, not Red Bull Dog. You're White Claw instead of White Paw.
Right.
And that just really goes down to the strength of these underlying products.
Totally, yes. And so, VIP, to your point, VIP really had to fire back here because of the strength of those marks and saying, look, this is clearly a parody, which is what they argued in their case, and it's protected as free speech under the First Amendment. And the courts really had to decide when this case it went through all the way up to the Supreme Court, and the courts that dealt with this case had to decide, is this expressive use, what you see on the screen with the Bad Spaniels bottle, or is it a violation of trademark law? So really what the court is grappling with is, where's the line? And that's sort of the topic of today's discussion, is where is that line? And why is it important to know where that line is drawn?
Yeah. Where here, if we just look at these bottles up here on it, right, this really goes more towards just kind of evoking the image of Jack Daniels, right? Some of the words are close, but I think the only literal elements that the same there is that they both say Tennessee.
Right. Yes. And I think that in these cases, it's really important to keep in mind that it's not a one-size-fits-all approach, and it's certainly not a one element will be the outcome determinative factor approach. Taking the literal elements in contextualizing it within the whole impression of the mark as someone would see it online or in the store on a shelf is going to be what the courts are looking at here. They're not going to pick apart the pieces of these products. They're going to look at it as a whole and make the determination on that in terms of, okay, what are the similarities? What are the distinctions? Is this parody a commentary, or is it really being used in commerce? And is this going to, kind of change the course of the way trademark law draws the line? Maybe so.
And I think one of the crucial things here, and strong distinction that Jack Daniels drew this line for, is the actual underlying subject matter, right? They don't necessarily want their product to be associated with a bad dog getting number 2 on your carpet, right? They're trying to avoid themselves from that. Where I know Jack Daniels, this goes back a bit, but the band Leonard Skinner had their
right.
T-shirt that has the exact same font, same style. Jack Daniels didn't really seem to care about being associated with Leonard Skinner.
Right.
It's the actual subject matter here that, on one hand, I think strengthens the parody argument.
Yes.
But then it also increases the reputational harm that
Correct.
Jack Daniels could be experiencing.
Yes, brand identity is definitely playing a factor here. And it's part of the reason why Jack Daniels is taking such an aggressive approach to policing its mark and making sure that its brand identity is staying intact and not being, diluted, so to speak, to use a legal term, by other companies who are arguably hijacking their brand identity and putting it on their products. That's how Jack Daniels would view it. So,
Yeah.
yes.
And they've been enforcing this harshly. I believe this case first started in 2014, over 10 years ago at this point.
It's a long time.
You'd mentioned it already went up to the Supreme Court.
Yes.
And then I think now it's back in the Ninth Circuit. And
Yes.
who knows what they'll decide, but another trip to the Supreme Court could be in the future.
That's right, and it's these trademark cases are so interesting because, to me, they're very tangible. This is an everyday product that you and I probably both see almost every day with pets around in the dog park, and we probably have dog toys in our homes. So when you see a case like this be elevated to the level of the Supreme Court and has that back and forth in the Court of Appeals, and you see it in the news cycle, it really is fascinating, and it's especially important for business owners and for executives and folks who are really interfacing with brand development at all, to keep in mind as well. So I think really the takeaway here is that the court understands that free expression is vital. First Amendment, free expression in the marketplace is vital. However, so is the integrity of trademark law. And that line is where the fun comes in. And you get to really play, and the court gets to, play around with these different arguments that both sides are bringing to the table. And I think that the more the court widens the companies across the country's ability to use free expression, the more narrow that trademark protection is going to be. Or, vice versa. It could go both ways. So it is really interesting to see develop.
Certainly, and I think something that also then plays into this is the realities of actually enforcing your trademark.
Yes.
Here, I
Yes.
got to give props to VIP Products, who are actually, in court zealously representing their position, where you see a lot of these infringing entities just pop up on Amazon. You get a takedown request, and then they pop up under a whole new company just moments later. Where here they're actually, out here fighting, trying to find out where this line is.
Right. And I think that it's important to keep in mind that what the courts are going to be thinking about here, and what consumers should be thinking about, is that parody has its place, and it certainly has its place in the market. But, it shouldn't come at the expense of that consumer trust or clarity of where trademark protections lie. So as consumers, when we're interfacing with products and we're looking at brands and we're looking at products like this that have like funny little spin-offs, it's important to keep that in mind, that as the consumer, what products are we buying, who owns those products, how are those products being marketed, and making sure that we're aware of the fact that other companies, well-established brands and well-established companies like Jack Daniels, are going to be, fighting back and maybe taking some of these, fun things to battle.
So after it was remanded from the Supreme Court, the Arizona District Court found that it was a successful parody,
Right.
and that while it was tarnishment of the trademark and that it was diluting, it was not infringement due to
Right.
that parody. Now, of course, that's what the lower court has said, and we'll see if Jack Daniels files an appeal.
Right.
But for now, we'll continue to monitor this litigation for any future developments. And thank you all for watching BL Business Branding.